Hello, everybody. My name is Mike Ward. I'm head of the patent group at Morrison Foerster. I'm also global head of our life sciences group. Welcome to our advanced patent topics course. Let's turn to our first slide. So first, I'm going to go over an outline of the course, and then we'll do a quick review. Many of you from our signups attended our course last fall, but I want to bring those who did not attend the course last fall up to speed really quickly. So we'll do a quick review from last fall to get everyone up to speed. And then we'll dive into today's topic, which is developing an IP strategy. So first, an outline of the class. So today, as I indicated, I'm going to talk about developing an IP strategy. This will be a more general discussion. Then we're going to turn next week to Anita Choi, who's going to talk about small molecule patent drafting and IP strategy. In our third session, Chris Gloria will talk about medical device patent drafting and IP strategies. In our fourth session, we have Liz Newman and Rachel Rice, who will talk about patent strategies for personalized medicine and diagnostics. Session 5 will cover biologics and patent drafting, and that will be taught by Megan Poon. Session 6 will be on patent and FDA strategies for new drugs, and that'll be Bridget Bondock and Lisa Silverman. The seventh session will be life sciences, AI, and machine learning, patent drafting, and IP strategy. We're going to talk about some case studies in that class, and that will be taught by Anna Yuan and Jean Nugent. Mark Whitaker will talk about trade secrets for life sciences. That's in the 8th session. In our 9th session, we'll have Nate Vogler and then Anna Leithley of Cartmeals. Cartmeals is a firm based in the UK, and Nate and Anna are going to team up to talk about patent drafting for the United States and for Europe. How do you write a patent application that'll be strong in both regions? And then finally, in our 10th class, in our final class of this session, Matt Carlin will talk about advanced licensing topics. So we have a great course this winter, and we're excited to have all of you here with us today. Quick review about sort of the class guidelines. Please use the Q&A function if you have any questions as this goes forward. We'll do our best to get your questions answered during the class. If we can't get it to today, we'll get to it later, but we want to make sure that you're asking lots of questions. We've already received a number of great questions in the class. For example, we have composition of matter questions and effective paths to protect that asset. We have questions about patent drafting and the prosecution process. We have questions about licensing and FTO, et cetera, et cetera. These are great questions, and we will make sure that we answer all of these as they fit into each class. So we'll make sure we get those answered, okay? The questions are fantastic. The more you ask, the better. It makes the class more interactive. Important to note, office hours are available for all students, all right? We're happy to answer any questions that you may have. We'll send out an email after each class offering you the ability to reach back to us if you're interested in questions about careers and IP. I know a number of you are postdocs and grad students and are thinking about this as a possible career. You have questions about IP strategy, questions about things covered in the class, questions about anything. What is life working at a firm like Morrison Foerster? I want to make sure everyone knows that we are actively recruiting, and we are very interested in folks who have strong degrees from anything from chemistry, molecular biology, AI, machine learning, medical devices, you name it. We're looking for talent. So if you're interested in hearing more about our positions, please contact us. So with that, we'll get started. Finally, if you have any technical issues, contact Nora Moore at nmore@mofo.com. And if there are other topics that you'd like to cover, in addition to the 10 we've got covered for this class, shoot us an email. Okay, now we can turn to the substance of today's discussion. So first, we're going to do a quick review of IP 101 from our last class. So for those of you who attended the last class, this should remind you of what we talked about. And for those of you who did not attend the last class, this will get you all up to speed. So we're all sort of have the same basic knowledge. So first, what are the types of intellectual property? Up on the screen in front of you, these are the buckets. We have copyrights, all right? Copyrights cover things such as photographs, software. Those of you taking pictures on your phone, you own the copyright with all those pictures on your phone. Trade secrets, those cover secret inventions, methods, customer lists, and tools. Mark Whitaker is going to have an entire course on trade secrets this semester. Then patents. We're going to spend a lot of time on patents. There are different types of patents. Some cover inventions, some cover designs. Then there's plant variety protection and plant breeders' rights. And finally, trademarks. So this is the world of intellectual property. Covers all the different types of IP or intellectual property that are available out there. All right. So let's talk about patents for a couple of minutes. So what are patents? Patents protect inventions. Patents are country by country. All right. I told this at the last class. I tell this every class I teach. The number of times when I'm in Boston or in Silicon Valley out here in California, and I'll run into an entrepreneur and that entrepreneur says, I've got a worldwide patent. I just smile at them. And you should smile too and realize that they're completely incorrect. There's no such thing as a worldwide patent. Patents are country by country by country. You may have a worldwide patent application, a WO or a PCT application that allows you to file patent applications around the world. But each country is a separate patent, right? If you want to protect in Europe, for example, you maybe have a European patent application, but at the end of the day, each patent has to go into each country. So you'll have a German patent, a French patent. So there's no such thing as a worldwide patent. Patents are a governmental grant of right to exclude others for a period of years. So for those of you who attended the class last time, we explained this point and we're going to explain it again because this is fundamental. This third bullet point, it's fundamental to everything we talk about for the rest of the course. All right. Many of you attended the class last time, you know the answer to this question. The answer to this question is the most famous invention in history. In our class, it's the glazed donut. All right. Why do we use this as a glazed donut? Well, here's the question we ask. All right, I have a patent on my glazed donut. Can I sell my glazed donut? It's a fundamental question, all right? You're the inventor of the glazed donut. You're ready to set up your business. Can you sell it? Are you able to commercialize your glazed donut? Well, what's the answer to that? The answer to that is it depends. What do you mean it depends? What does it depend on? Well, in this particular fact pattern, what it depends on is the fact that there was an earlier donut patent, right? You see a donut on the left, which is an old donut, which didn't have any glaze. In our fact pattern here, there's a patent that covers the donut, all right? The inventor of the glazed donut comes along and has an improvement on that donut, and he's able to get a patent, he or she is able to get a patent on the glazed donut, all right? In order to sell that glazed donut, what does he or she need from the owner of the patent on the donut? He or she needs permission. What's another word for permission? He needs a license, all right? So you may have a patent on your glazed donut, but you can't sell that glazed donut unless you get a license from the broader patent holder, the owner of the donut patent, all right? So what about this owner of the donor patent on the left? He or she has been selling these old donuts and wants to now sell a glazed donut. What does he or she need? He or she needs a license from an owner of the glazed patent. So in order for this business to work, you need cross licensing. You need licenses back and forth in order for them to move forward. Okay. So patents do not give the inventor the right to sell his or her invention. Okay. The owner of the glazed patent doesn't get the right to sell that. What they do is they get the right to exclude others. Patents are an exclusionary right, all right? They give you the right to exclude others from making, using, selling, importing, and offering for sale the claimed invention. You might have a patent, but somebody else may have a broader, more dominant patent, okay? So let's go back to that bullet point that we were talking about. This one here, what are patents? Patents are a governmental grant of rights to exclude others for a period of years. Patents are not a grant of a right to sell donuts. It's a grant of a right to exclude others, all right? This is fundamental to understanding what patents give you, and will be fundamental to our strategy discussions as we go forward today and the rest of the course. Okay, so final bullet point here. You may have a patent. You may have a patent on your new drug. You may have a patent on your new delivery device, but someone else may have a broader, more dominant patent that you need to sort out. You may need a license or something else. So always keep in mind, do I have a donut problem as you move forward commercially? Okay. All right. So now everyone is up to speed. That was the key to our first course. I was going to check Q&A here, make sure I'm not missing anything. Questions? Will the recording be available? Yes, there will be recording. Is there CLE credit? No CLE credit. Will presentation slides be available? Yes, the presentation slides will be made available after each class. Okay, so let's now talk, how does one go about developing an IP strategy? All right, so we get calls all the time from people forming new companies, people who are working for an existing company. They've been tasked by their board, and the question from the board is, what's our IP strategy? And so we get calls from clients, prospective clients, saying, my board has come to me, and they want to know what my IP strategy is. And what do we do when we get such a question? Well, the first thing we do when we hear such a question is we ask, well, what's your business strategy? Well, why do we ask that? Well, you cannot craft an IP strategy in a vacuum, okay? It all starts with the business. So when somebody comes to us and says, all right, I understand you're really good strategically, you're really good at developing IP strategies, we understand your firm's well known for that. We always turn that around with, all right, we need to understand the business. So what do we mean by the business? What does that mean when we're talking about things, all right? So what we want to understand is, what are your products? What and where are your markets? Where are you going to sell stuff? Who are your competitors? What are your competitors' products? How can you increase market share? Our fundamental question is, how are you going to make money? What is it that your business is all about? Because once we understand that, and once we understand what you're going to do, then we can start to think about, how about we're going to protect this? How are we going to put an IP strategy that lines up with your business strategy? All right, that IP strategy needs to be consistent with your business strategy. It needs to be updated regularly, and many businesses change and morph over time. You form this company, you license some technology out of the university, you're going to do X. To work on X, you realize X isn't going to work. We're going to have to pivot here. We're going to have to do Y or something, X plus Y, all right? So as your business strategy changes, you need to go back and update your IP strategy so that they are constantly aligned, all right? One of the best ways to do this when you have a company, even a small company of 3 or 4 people, a startup that you're forming, is to form an IP committee, an intellectual property committee, a group of individuals at the company, and this doesn't matter how big or small the company is, but that committee's focus is on intellectual property, all right? That committee requires input from the patent team. Who are the people writing the patent applications? You need input from the scientists. you need input from the business development people, and you need input from management, all right? When startups are formed, often there's 3 or 4 people getting going and everyone's on the IP committee. The people are wearing multiple hats. You'll see people who are doing business development. They're trying to understand what the market is. So what are we, when we're going to sell something at the end of the day, how are we going to get that out there? So that business development person is on that committee. The scientists are on the committee because they've helped form this company, all right? Often management is the same as the scientists. So you have this sort of same people on here. What happens as the company starts to grow? Well, what we see is that people tend to fall off, or you hire new people. For example, the person who'd been doing business development, their job was to sort of understand what the market was, to understand what it is that we're going to sell. They stop wearing that hat as a founder in the company, and you hire somebody from business development, all right? What happens then? Oftentimes that person who gets hired doesn't get put on the IP committee. What happens then? Well, you suddenly lose connection. The IP committee loses connection to the outside world. They don't know what competitors are doing. All the competitive intelligence that was being brought in from that business development person who knew what other people were doing. And as we talk about the IP strategy, as we go forward today, you're going to see that that information is critical to the company. So it's really important when you have an IP committee that when you have the 4 people who know everything that's going on with the business, that sort of knowledge and information doesn't go away as the company grows. So it's important to keep those sorts of individuals on your IP committee going forward. So that means your IP committee is going to need to change. You're going to need to have different people as the company grows and matures, as people stop wearing multiple hats and start focusing on one thing, and you hire other people to do those other things. You need that information to flow back to your IP committee. And it's important to consider all forms of intellectual property protection within that IP committee. So again, back to what we were talking about earlier today, we were getting everyone up to speed. You need to be thinking about copyrights and trade secrets and patents and trademarks. All of those things should be considered by the IP committee. All right. So turning now to IP protection for the business. You understand the business strategy. You understand the markets. You understand what the company is trying to do. Then what do you do? Well, it's important to wear a couple of different hats and to sort of look at this from 3 different main angles. First, the sort of defensive positioning. We'll talk about that in a minute. Then offensive positioning. And then finally, monitoring the competition, the sort of business intelligence about what's going on out there, all right? So let's dive a little bit deeper into what we mean by defensive, offensive, and sort of monitoring the competition with respect to IP and your strategy. All right. You want to build a comprehensive IP portfolio. That will include defensive patents and offensive patents. So what do we mean by defensive patents? Well, defensive patents are patents that exclude others from practicing your technology. Remember, we talked about with the donut is that patents are exclusionary rights, all right? So when you talk about defensive patents, you're talking about excluding others from practicing your technology, what it is that you do, all right? You want to make sure you establish protection for what you're doing, and you want to make sure you strengthen that protection to make it as strong as possible. So that should be a part of your strategy. Then what are offensive patents? Well, offensive patents are patents that exclude others from practicing their technology, okay? So you can see how these Venn diagrams starting to overlap, okay? When we talk about monitoring the competition, we need to understand what the competition is doing so that we can start to write patent applications that cover their technology. Why? Because we want to block the competition, particularly if they might be getting close to us. They may be doing things by a different way, but if we can craft our own patent applications and patents with claims that might block them, all right, what can we do? We can potentially complement your own patent portfolio so that you may go acquire that other company, okay? So to build your own value, that other company may have some things that are really interesting and useful to you. And if you've got IP that blocks them, prevents them from doing what they want to do, they may be ripe for acquisition. All right. You may be setting it up for you to acquire them simply because you've crafted IP that's going to keep them out of the market. Okay. So that's what we mean when we talk about offensive. So think about defensive patents. They cover what you're going to do, and offensive patents that cover, it may have very little to do what you're doing, but you know enough about what the competition is trying to do that you're going to write your own patents that would cover the competition. Okay. So that's the offensive and defensive end of things. All right, let's talk a little bit more detail here now about the defensive strategy. Remember, we're trying to block others from copying our own technologies. So I'm just looking at the Q&A. What do you mean by more dominant patent? So what I mean by more dominant patent is a patent that is broader. And for instance, in our donut example, all right, you would have a patent on the glazed donut, and you would have a patent on any donut. The patent on any donut is broader. It's a dominant patent. It would cover any type of donut. So if you were to take a donut and put sprinkles on it, you would need a license from the dominant patent holder on the broad donut patent. If you, it would cover glaze, it would cover sugar, anything else that also, it's a broader patent, where our glazed donut patent is more narrow and covers our specific product. All right, let's talk a little bit about the defensive strategy. All right, first, we have to cover our company's products. All right, we need to think of each product that we have in our sort of, you know, the things that we're going to sell as complete and discrete assets. All right, there might be systems, there might be components of the systems that are individually and separately patentable. You may have kits, things that you put together that work in conjunction. There may be methods, so you can get method claims that would protect it. You may protect the actual compositions. There may be some new chemical entity that you've identified. All right, there may be methods of making that chemical entity. There may be methods of using that chemical entity, right? All of these things should be a part of your defensive strategy. And again, what is defensive? It's what you do. It's how you make what you do. It's how you, excuse me, package what you do. It's how you put it together. It's how you market it. It's how you sell it. You want to cover all those things, right? Your IP plan should be parallel to your R&D. So as your R&D, your research and development is going forward, you want to make sure that your IP plan aligns with it and lines up with it, all right? Many companies will end up with a product that doesn't look anything like what they started with, okay? It's important to go back and look at your IP and make sure it covers that which you evolved to, all right? You come up with one idea, you meet with your patent attorneys, you write a patent application, the inventors go back and they say, well, this doesn't work, I got to tweak this, all right? That's time to go back to your patent attorneys and say, hey, look it, we've evolved, we've improved this, we need some help here, all right? We got to write some more patents in order to cover the changes in our technology. So you need to make sure that your patent filings are up to date on what's the commercial product going to be, right? We always, when we consult with clients on strategies, we are always asking the question, have you sold anything yet? No, we're getting prepared to sell. Well, have you offered your stuff for sale? Because an offer for sale, when you put a price on something, can trigger a bar. What's a bar? A bar is, it will prevent you from getting a patent. So in the United States, if you've offered something for sale more than a year before you filed your patent application, you're out of luck. Outside the US, if you offer for sale or sell before you file your patent application, you may be completely out of luck. So it's really important to keep that communication going as you're ready to commercialize, because oftentimes software, various tweaks to products, things are getting tweaked along the way, changes are getting made all the way up until the point of commercialization. You got to make sure that that new information is in your filing. We often get these rush patent application projects here at the firm where the client is just tweaking the technology all the way up until launch, right? Once that you got to get it's finalized. If you're going to, sell tomorrow on this finalized product, you got to file on that new version before you sell. All right. So that's why IP and commercial need to be talking all the time. All right. It's really important that you establish protection for all the products. So this communication with your IP attorney is really important. All right. I was just telling you about how products morph all the way up until they're about to sell. Okay, you need to be in constant communication with your IP counsel about, all right, here it is, it's tweaked again, We're changing things all the way along. You might make sure that you file on those things, all right? That's why it's very important that your IP attorney understands the business, understands the timing of the business, understands that you guys are going to sell. You're going to sell version 1 today and version 2 in another 2 weeks. You need to be ready with that and protected before you sell. It's essential that your employees are educated about this whole process, all right? Too many times we have come across situations where the folks on the business side of things are so excited to sell their new product that they're offering it for sale before they've talked to their IP counsel, all right? It's essential that your BD people and your business people understand the rules of patentability and understand that it may be great that they're going to have $1 million in sales on some product, but if you have no protection for it, simply because the person got so excited about it and wanted to, sell before you filed the patent application, that $1 million in sales may plummet as a knockoff comes in that you can't stop. All right, so communicate, educate your employees so they understand the process, understand how patents work, and understand the timing of things. It's essential that people in the company understand how to identify what's patentable, because the difference between what's patentable and what's not patentable can be very, very subtle. And sometimes with a good, crafty patent attorney, you can come up with an idea and a way to protect something that gives you protection that everyone said, no, there's no way you're going to be able to protect this. Don't make that decision on your own. Contact an expert and talk about it. Is there any way we can protect this? All right. Again, you want to prevent a loss of rights. It's all about timing. All right. You need to file before you sell. You need to file before you sell a revised version. You need to file before you offer for sale. All right. That strategy that we're talking about needs to be constantly evolving. All right. See, we've got a lot of questions. I'm just going to check that, see if there's any I can answer. All right. We briefly mentioned WIPO. We're going to talk more about WIPO and other courses and other classes this year. There's a question. I thought broader patents are less defensible when litigated. That's not necessarily true. You want to have the issue here is on if you have a very broad patent, is it possible that it would be more susceptible to challenge when you try to enforce that patent? That's possible, but that's why you want to have broad patents that cover things broadly and also more narrow patents that cover precisely what you're up to. Is it better to wait to write an all-inclusive patent for a method or write a series of patents as you improve it? We recommend that you write a series of patent applications as you're going forward. Anytime you tweak the process and you're about to publicly disclose it or commercialize it, you should file your patent application. All right. Continuing on with the defensive strategy. It's very important that you strengthen your position continually, all right? You want to file for patents in your key countries, not just your home country. You may be based in Europe. You may be based in the US. You want to file so that you protect more broadly, protect the key markets for your product, all right? You want to think about filling in gaps in claim coverage. As you look at your claims and look at the patent applications that you filed, you want to make sure you have layered protection. This goes to that question that somebody asked in the Q&A about broad very broad patents and very narrow patents. You want to have a spectrum. We call it layered protection. You want to get as broad as you can and then have various fallback positions to go increasingly narrow down to where you cover your exact product and everything in between. So in case somebody challenges your patent and tries to knock it out because they find some prior art that may knock out your broad claim, you're going to want to have narrower claims which will withstand such challenges. All right. Make sure you review your claim language very, very carefully. Make every word count. When we write patent applications, when we're about to file them, we go back and we teach our folks to literally read the claims backwards. So it forces you to look at every single word in that claim and understand, is it necessary? Because an additional word in a claim can make your claim more narrow and perhaps allow someone to design around it. So look at every single word, and I find the best way to do that is read the claim backwards from period to the start of the claim so that you understand it. Why is that word here? Why is that word here? All right. You want to make sure you're reviewing those claims with your engineers and inventors and ask them the question, okay, here's the claim that we have. Put your design around hat on, put your competitor's hat on, look at that claim. How can I design around that? How can I do it differently? All right. Again, make every word count. We talked about that. Think about alternative claim strategies. What's the real advantage of your invention? What's the problem that it's solving? Okay. Another thing to consider in your defensive strategy is licensing and acquiring additional IP to bring into the company. This comes down to the competitor monitoring and understanding what your competitor is doing, what's out there. Would that complement your own company if you were to license in some additional technology? You may license in some additional technology that would allow you to block other competitors. Those are things that you want to consider as you build your portfolio. Okay, just going to look at questions before we go to offensive. Okay, we're going to get to all of these types of questions as we're going forward. Let's keep going here on the strategy. All right, let's turn to offensive strategy. Remember, what are we talking about with an offensive strategy? We are talking about blocking our competitors, okay? So you really need to understand the competitive landscape because what you're trying to do is block the competition. Okay, you need to anticipate what the competition is doing and where they're going. This is why it's important to have your business development team out there attending BD meetings, attending presentations by, at scientific meetings, going to other sort of situations where you can see what the competition is doing. Okay, so you want to look at new filings. You want to look at old filings where you can maybe tweak those claims, file new claims. If you keep your patent applications pending for a long period of time, you can file additional claims in those applications. All right. You want to complement the portfolio of a potential acquirer. Okay. So think about it. You're a small startup and you are looking at ways at which the company can have a good positive exit. You can think about IPOs. IPOs are wonderful, but sometimes those take a long time to get to that level and are not always in the cards. Sometimes it's better to simply grow your company to a certain size and then be acquired, have somebody else buy you, all right? And one of the ways that you can do that, increase the value of your company so that it looks more attractive to a buyer, is to go out and acquire IP. Because it helps you differentiate yourself from the competition. All right. When big pharma is looking for small, companies that have really good technology, not only are they looking for really good technology, but they're looking for robust patent portfolios. You can increase the value of your portfolio by acquiring other portfolios and bringing those into your company. All right. So this all goes with monitoring the competition, all right? You need to know what's going on out there. You remember the Venn diagrams, okay? those monitoring efforts need to be continuous, all right? You need to be watching your competition all the time. You can be watching their patent filings. You could be watching them from public announcements, what's going on. You can go to meetings and see what they're talking about, because this allows you to frame both your offensive and defensive strategy. In order to do this, you need to know who are your competitors, who's out there. There may be new competitors popping up all the time. What are they doing? What are they up to? And what are their patents cover? Where are they going? Many people will monitor, for example, Apple, because it allows them to sort of get a window as those patent applications publish 18 months after they're filed to see what Apple is working on and what's going on, all right? So you can also set up alerts where you're monitoring patent and non-patent literature alerts. So you can look for patents that get published, and you can also look for publications, because this helps you identify what's the scope of what they're working on, all right? It may also stimulate thought within the company. What are other areas of interest for us? And it may also help you to identify potentially problematic patents. Do you have a donut problem, all right? It's important to know that early. There's nothing worse than being a small company that is going forward, trying to bring investment in, and you haven't done any searches and you don't know what patents may present problems. And your investor, before they put money into your company, does some diligence and they identify some problematic patents, all right? Far better you knew about those patents and figured out a solution before some investor comes and says, well, what about this? You need a license or you need to figure out a way to design around this, right? Stay ahead, monitor the competition. Okay, so we've talked about offensive and defensive patents. We've also talked about monitoring the competition. And we talked early on about the business strategy, and we talked about IP strategy. Now, how do you ensure that those things are aligned? How do you ensure that they are constantly being updated? Okay. It is essential that you establish an IP savvy culture within your company. All right. Management, scientists, engineers, BD, and finance all need to be on the same page. All right. I think this is one of the most differentiating factors in looking at successful startups versus unsuccessful startups. Successful startups take IP seriously. Not only do they take IP seriously, they take the time to get themselves educated about intellectual property, doing what you guys are doing by attending courses, bringing your attorneys in to talk about this. This sort of class that I'm giving right now is something that all businesses should hear. Everyone in a startup should understand all these things, the basics of IP and how to go about this so that they're educated about it, right? You need a startup mentality with respect to IP that continues as the company grows and grows from startup into a larger company. Too often, IP savvy companies lose that momentum as things get going forward. They get busy. They get, bogged down in regulatory issues. They get bogged down in other things, all right? Don't lose that IP focus. You lose that IP focus, the value of the company can just plummet, all right? We talked about forming an IP committee. I think that's an essential thing. You need scientists and engineers on that committee. You need to understand where is the technology going within the company and outside the company. All right, we talked about the value of a business development team on there and understanding what the competitors are doing. You also need an IP legal team. For small companies, that's often simply outside counsel. That's often firms that are working with the company. As the company grows, you may hire in-house IP lawyers or patent agents who help with this, right? But you need members of this IP committee need to be trained in IP, all right? And you need to guide this IP committee regarding patents and trade secrets and trademarks. You need to be talking about this, all these different types of IP. All right, so what's one of the first things you form this IP committee within the company? What's one of the first things you should do? You should form an audit. You should perform an audit, an IP audit. All right. What does that mean? All right. You need to review your current systems. All right. Do you have systems within the company that track innovation? Do you know the improvements that are happening within the technology? How is that information recorded? How is that information kept, right? Is there a system within the company to protect trade secrets? Mark Whitaker is going to talk in a later class all about trade secrets and how to protect these. But it's essential that your company has a system that you can point to. When we are doing diligence on behalf of investors and companies, what's one of the first questions we ask? Do you have a trade secret policy? Do you have trade secrets? Or how are they identified? Who knows about these trade secrets? How do you keep them secret, right? These are all essential questions. You then, after you've looked at the systems, you need to look at the current IP. What do you got so far? You've got patents, trade secrets, and trademarks, hopefully, right? And you need to take a look at the strength of that intellectual property. We'll go into that in a minute. How do you assess the strength of the IP? Then you'll also need to assess freedom to operate. What is freedom to operate? Freedom to operate is the ability to sell. It's the donut problem I keep talking about, right? Does somebody have a broader patent that may cover what I want to do, right? It needs to be done on a country by country basis. Why? We talked about this earlier. Okay, why do we need to do this on a country by country basis? Is that patents are country by country. So you may find a patent in the United States that has certain claims, and the corresponding patent in Europe or China or Mexico, for that matter, could be much broader for some reason, all right? Claim scope can vary country by country. So you need to understand your freedom to operate problem on a country by country basis. You can't simply look at the US and say, oh, I'm fine in the US. I'm sure the patents everywhere else are also fine. No, you need to understand what's going on in each of those countries. Why? Because in the United States, for example, there are things called willfulness issues. And what does that mean? Well, willfulness issues means if you know about a patent and you keep infringing, you could be held to be what is known as a willful infringer. What happens when you're a willful infringer, right? In a patent lawsuit, when you're sued for patent infringement, and I'll talk about this more in a few minutes, but when you're sued for patent infringement, right, and the other side wins, the next phase of that trial is the so-called willfulness phase, right? So you will have to pay damages in the first phase. That could be a reasonable royalty or lost profits for your infringing act. But then if the courts find that the judge finds that you're a willful infringer, you may have to pay triple those damages as a willful infringer. And you may also have to pay the other side's attorney's fees. All right. So you're defending yourself and now you're paying for the other side's attorney's fees in addition to treble damages. So willful infringement is something you've got to be very, very cautious about. All right. Turning now, how do we assess the strength of our patent portfolio? All right. First question you got to ask, do the patents cover your key products? Well, we talked about this earlier. Products evolve continually over time as improvements are made, software is changed, devices are tweaked, right? As those things are changed and tweaked, do our patents still cover the newest version? That's an essential question. If they don't, can you fix that? Okay. How much protection is provided? Do you have enough protection? Do you really cover all the small design arounds? If it's weak, can you fix it? All right. How can patent protection be fixed? When you file patent applications, a patent application will be examined by the patent office. You may proceed to allowance by the patent office and then proceed to grant. All right. So you have filing, then examination, then potential allowance of your claims, and then grant. During that process, at any point during that process, prior to grant, you can file what is known as a continuation patent application. Continuation patent application takes the same patent application, is filed with the patent office. It has different claims than the parent application that was filed. So long as that continuation application is filed before the patent grants, you still have a pending application. So back to this question of, can it be fixed? The answer is, well, maybe if you have a continuation application still pending, you can go back and get different claims that will cover those tweaks. It may not be able to cover those tweaks if you don't have enough disclosure in that patent application to cover those tweaks. But You have no chance if you haven't kept a continuation case alive. If you've allowed that patent to grant and there's no pending family member in the United States, you are out of luck. So that's a threshold question that you always need to ask as you're doing diligence on the portfolio. Did you keep a continuation case pending to allow us the opportunity to change those claims to try to cover something else? All right. When will the patents expire? How much longer do they have? Have maintenance fees been paid? All right. Maintenance fees are required not only in the US, but elsewhere. They come up at 7, 14 years. You got to make sure that those fees have been paid. If they haven't been paid, why weren't they paid? These are things that you need to sort through in assessing the strength of your portfolio. Finally, are the patents valid? Do they cover the product, and are they valid? Meaning, is there some prior art that's out there? Was there a prior sale issue that's out there? If not, can that be fixed? Again, how do you fix something? You need a continuation case in order to fix it. All right, diving deeper into various patents, all right? You're gonna wanna look at prosecution history review, okay? What does that mean? Prosecution history is the correspondence back and forth between the patent office, okay? You file a patent application, the patent office examines it, sends you a letter saying, here's why we reject your claims. You file a response to that office action, arguing why your claims are patentable, all right? When you make those arguments about why your claims are patentable, you may run into estoppel issues. What are estoppel issues? Estoppel issues are issues when you've said something in response to the patent office, no, my invention means X, my claims mean X, all right? And they don't mean Y, all right? You are now stopped from arguing later in life of that patent that your patent claim means Y, okay? So these are issues that you need to sort out. Have you created an estoppel issue during the patent prosecution? If you've disclaimed and said, no, my patent doesn't cover Y, then your competitor comes in and he or she is selling Y, you can't cover Y because you've made a statement in your file wrapper, even though your claim as granted in the patent office may say something that seems to suggest it would cover Y. If you've said something in your file history that cuts that off, you're stopped, prevented from saying now later that it covers Y. All right, so there's a variety of other things as you assess the strength of your portfolio as you go through the prosecution history. Sometimes you can correct it with a certificate of correction. Other times you cannot. So there are things that you want to assess as you go through the prosecution history to understand the scope of coverage. Okay, so the donut problem that I keep coming back to, this is the freedom to operate issue, all right? Is there a risk that you might be infringing a third-party patent, all right? Have you done any searching? Have you done any analysis? That needs to be updated regularly. Patents are granting all the time. You may have done a freedom to operate study a year ago, or even 6 months ago, and things change. That needs to be regularly updated. This is something that your IP committee can do. You also should be watching patent applications. Remember that patent applications will publish 18 months after they're filed. You need to look at those claims, you need to monitor them, and you need to track them and follow them. They may be written really broadly, but as they go through prosecution, they get narrowed and narrowed, but you're not sure of that. They may not happen. So you need to assess the risk that that patent is going to grant in its current form and monitor it. And if it does grant, and it's so broad that you've got a problem, then you need to think about ways that you can go about attacking that. All right. Ownership is an essential component to assessing the strength of your portfolio. All right. Does the company own it all? All right. Have the inventors assigned their rights to the entity? Have all those assignments been recorded? All right. Do you have previous employer problems? All right. Are there any inventorship issues? We talked about inventorship in the last course last fall and how you determine that. But have the proper inventors been named on the patent application? Okay. Some additional considerations, then we'll come back to the questions. All right, thinking about licensing or acquiring IP, and then finally enforcing your IP. What are some considerations there? So Matt Carlin is going to have a whole session on licensing of IP. but let's talk a little bit about some of the considerations in licensing IP. And then Matt will talk to you about how you actually do it. So what are some of the considerations? All right, first, how do you go about finding patents that the company may be interested in licensing? What are the things that you're going to be looking for? You want to look for patents with a longer term, so something that's recently granted. So as a part of that search that we were talking about, this freedom to operate search, you can be identifying patents that might be relevant to the company. You want to be looking at, are the claims broad or are they narrow? Do they cover something that you're interested in? Patents that have live families could be more valuable. What is live families? I just talked about this continuation, keeping a continuation case pending. That means it has a live family. That means it opens up the possibility of filing some additional claims. So you want it, that would be a more valuable portfolio than a portfolio where every jurisdiction has granted patents and it's all done. The family is dead. You can no longer file any more applications. If you keep cases alive, it's more valuable, right? Patents that have been tested in a litigation context can be more valuable. If they've already won a litigation on those patents, it may be more valuable. And similarly, if you identify inventors who have had good success with patents, those can be more valuable things to acquire. How do you go about evaluating what it is that you're going to acquire? Well, first, you can look at lost profits or a reasonable royalty. What does that mean? Well, lost profits are the profits that one would lose because they're not able to sell the product because somebody is infringing that product. So if it's the profits that you otherwise would have gained. So you also calculate royalties, reasonable royalties. That is, I have a patent on something and you want to sell the product that's covered by my patent. I would charge you a reasonable royalty, something like 2 to 5, 7% or something of the product that you're selling. That's the royalty. Those are the ways that you assess the value of the patent. What's the royalty that may flow back to you if you own that, all right? You target one or many, or how large is the target that you're going after? These are all things to consider as you look at whether you want to license or acquire something. Has that target that you're talking to, does it have some sort of licensing or track record here? If they do, then you may have some sort of information or intelligence about how they go about licensing things and what do they usually charge. So that's, again, intelligence that your BD people can bring back to you. All right, turning now to enforcing IP. So it's important to understand that intellectual property is merely a piece of paper if you're not willing to enforce it, okay? Example I love to tell is my particular area of expertise is in plants. So I'm often out in the field talking to plant breeders as they're looking at new plants as they're developing. And I was out in the field one time and a breeder was showing me these various tomatoes that were out in the field. And the breeder says, each of these is covered by a patent. And I said, oh, really? And he said, yeah, but these first three here are covered by patents by companies that don't enforce their patents. So we don't care about that. We're just going to keep using it. That fourth tomato over there, those guys enforce. We're just going to grow these today and then we're tearing them out essentially tomorrow is what he was saying. To me, when I heard that, I thought about the business sort of associated with that and the value of the intellectual property. The first three companies, they're spending a lot of money on their IP, but their IP isn't worth anything because they had no respect. The breeder said they don't enforce, we're not going to be worried about it. The fourth company that spends similar amounts of money on its IP, but sues people when they infringe, the value there and the knowledge, the business value there, you can't quantitate it. That breeder was not going to use that stuff in breeding, all right? That's why IP is merely a piece of paper if you don't enforce. You have to be able to enforce, but enforcement is expensive, right? If you look at a case for a branded side drug, you're looking at $6.2 to $15.7 million for a $25 million case. That's the cost associated with the litigation for attorney's fees, all right? And your actual costs are likely going to be higher. And it's going to have to be appealed. And if there's a lot of money at stake, it can keep going on. And even if you win, it might be years to collect. So you need to have the stomach and you need to have the money to go ahead with litigation. All right. Are there ways that you can make it perhaps more affordable? All right. There may be contingency fees. That is, you can get a lawyer to take on your case where that lawyer will not charge you in order to get a percentage of the outcome. That's rare. It does happen occasionally in IP litigation, but it's rare. And there might be other alternative fee arrangements where you can defer fees and costs and give the law firm some sort of upside to winning the case for you. Then there are certain hedge funds and others that will invest in various IP litigation matters. You can also think about selling or auctioning your patents in order to raise money to enforce them. Okay. What's the downside when you go ahead with a litigation? Well, you may get countersued. You may sue somebody for infringement, and they may turn around and say, in our donut example, you sue somebody starts selling glazed donuts, and it turns out that the glazed donut person who's selling also has a broader patent that covers your method of making glaze. Okay, they may countersue you for that. You got to be worried about that. Are your feelings got to get hurt if you're called a troll? I don't think that's a huge problem, but it's something to think about. But the worst case scenario is that your patent gets invalidated, knocked out. You have a huge opportunity cost because you've lost a tremendous amount of time, fighting this out. And you may have to pay the other side's fees. And you may have demoralized employees who fought so hard and paid all these legal expenses and lost all this time only to lose the case. It's nothing more demoralizing than that. There's also nothing much more exciting than winning a case that you've spent a lot of time working on. So it's something to think about. How long it's going to take? Really unpredictable. It can take around a year in different courts. Other courts are 2 years, some are 3 or more. Depends on where you sue. And you have to, this is just for the district court case. Appeals and potential remand take even longer. Okay. So are you prepared to be a plaintiff? Do you have enough money? All right. These are really critical questions. So conclusions from today's talk. It all comes down to your business. Make certain that your IP strategy aligns with your business strategy. And as your business evolves, make certain that your IP strategy also evolves. So I've got a minute or two here. Let me see if I can get to some of the questions. So there was a question, can you file multiple continuations to keep a patent pending indefinitely? Yes, you can, all the way up until 20 years from the filing of the first patent application. There's a question on Hatch-Waxman. We're going to talk about that in another class. Now, all of these questions are great, and we're going to be addressing them as a class sort of continues. So I just want to thank everybody for coming. These are great questions. We're going to save these and make sure that they are answered in the appropriate class as we go forward. So wish all of you guys a good day. Look for an email from us, and we'll talk to you guys soon. All right. Thank you.